Oh, there we go. Got it. All right. I got the last little warning button. All right. So happy to see everybody. I know we're missing Ms. Williamson, but I think she'll be, well, we'll see if she can join us. So just to do a call to order, Mr. Vogel, if you don't mind just doing a roll call.
Certainly, Madam Chair. Ms. Dawson?
Present.
Mr. Esme?
Present.
Ms. Evans?
Present.
Mr. Taylor?
Present.
Thank you. And Ms. Williamson?
Just as a reminder, this time doesn't work for her till about 20 after or whatever. So
Yeah.
I was trying to remember if it was this one or the Wednesday morning chair one. I knew there was something with both of them. So
Yeah. But yeah, Madam Chair, a quorum is present.
okay, perfect. So with that, I know we had our last meeting on April 4th. The meeting minutes have been posted to the task force website. If anybody has any corrections or notations, if they, please let me know now. All right. Hearing none, then the meeting minutes are approved. So kind of just to circle back with everybody at our last meeting, we were able to outline sort of our plan going forward, which I think was very helpful, and it's helpful to have that established for this one. And I apologize, I actually don't have the schedule up in front of me, but I know at least this one and the next two meetings, I think it is, we're planning to look at the permanent bars. At some point, we're hoping that Max Page from the county attorney's office will be able to pop in just to give the perspective from the county attorney's side of things. However, so I think if he does pop in, whatever discussion we may be on will kind of shift to, of course, get his perspective as well. But so the plan now is to really start discussing the permanent bars. And I think, Mr. Vogel, you had indicated you were able to give at least a brief rundown of the legislative history of the permanent bars. So I'm wondering if it makes sense to kind of start there and then go. I've been trying to do some work on it on my end too, and I can give any updates as we go along as well.
Certainly. Thank you, Madam Chair. Although
And I see before you start, Ms. Evans has her hands raised.
did we hear from Max? He was not going to be able to make it today?
Last week, or the last one.
Yeah, Ms. Evans, Madam Chair, we haven't heard from Mr. Page for this one.
Because he said he was going to be able to make it today, correct?
Ms. Evans, I haven't heard one way or the other from him. I just heard that he was a maybe on last meeting, this meeting, or the meeting after that.
Okay, I'm going to text him.
Okay.
Okay. And Mr. Esme.
Yeah, can I just ask a question to sort of clarify the scope of the discussion? So kind of the permanency element of the statute, as I understand it, comes into play in sort of two separate but related ways. The first is that some crimes have a permanent duration of the disqualification period. And then separate but related to that is that same list of crimes have a bar to ever getting a set aside. So when we say a permanent bar, are we only looking at the second part because this is the Remedies Subcommittee, or are we looking at the entirety of it?
That's a good question. And if anybody has any different, my understanding was when we're talking about just the permanent disqualification, should it have been something that maybe the disqualification subcommittee should have looked at, but I think it kind of got passed off to us. So I do think that we are looking at specifically, sorry, I'm looking through some of my notes here, where it's the actual permanent disqualification. So that is what we're tackling at this point. I think your second comment about the second part about permanent bar to a set aside, to me, at least, that would come up in that process, which would be the third topic we're going to be talking about. But that is actually further out. I believe we won't even start tackling that until August, if I'm not, or July.
Okay.
I think we tried to separate them out so that we didn't get too lost in which one. kind of thinking that tackling this permanent, just the actual permanent disqualification is a smaller topic to just try to tackle right away.
Sounds good. Thank you.
Dewan?
Both of them.
Yeah. But both will be covered, just separately.
So I just want to make sure I'm hearing this correctly. So we're going to be tackling like the certain like the individual bars, or just looking at this, that that's relevant, that's really relevant to me. And like just looking out for other people that has happened to previously. Like maybe that has been like I can't be the only person that has been approved of a set aside and then had it taken away from them for something that nothing new that happened. So I'm wondering if, like, how will we be able to identify that? Because there's too many people that has put in. There has to be others.
Yeah, and I know Mr. Vogel, I had said you go first, but maybe I'll just jump in right away to answer some of that, Dawn. So one thing that we talked about, and that I know Gina got her portion put together, and mine is just taking a longer time because I'm finding the federal code to be an awful rabbit hole to go down. That is sort of blowing my mind.
Yeah. Oh, sorry.
No, that's okay. So one thing that we were looking at doing, and I think some of this will be helpful when we go back to the large full committee or the full task force, because I think we've kind of all realized, at least in this small group, while we don't exactly all think the same and we're not all exactly aligned, I think, are fairly close, which has allowed our subcommittee to get a lot of work done compared to some of the other subcommittees. And so, but one thing that we talked about doing was really outlining sort of bullet points of the specific crimes that Minnesota statute uses as a permanent bar, and then directly comparing it to the federal, because we keep going back to, it's all underarching under the Adam Walsh Act, the federal requirements. And so that's what I had been working on, was really trying to bullet point the federal, which is proving to be, it's not like Minnesota where we've got it. That's one nice thing about our statute, where it's very clearly listed. The federal is the Adam Walsh kind of gives you these terms, and then you have to dig into other areas to actually figure out what those definitions are. So that's what I have been trying to spend some time on. And then some of them were, there's cases that make certain portions unconstitutional. It's been some work. So yeah, so go ahead, Dawn, if that helps some too.
It's kind of separate but kind of similar. Like I had this similar situation happen. I applied at the VA hospital and got hired. It was, I guess, my honesty got me hired or whatever with the guy, that I was hiring. And I didn't think I was gonna get hired, but they hired me right away. And then a year and a half later, we got a new chief. A new chief was hired because I was in shipping and receiving downstairs, walking around, just people around in wheelchairs and stuff like that. And a new chief was hired, one retired, new one was brought in, and it was one of the documentation. He said I shouldn't be hired there. He said I shouldn't have been hired there. I've been here a year and a half, employee of the month, all this. And he said I shouldn't be there. I've had the key to the office. Nobody, like 3 people have it. It's like $200-some thousand is always in there. For like a year and a half. No problem, no incidents. He don't want me there. You get what I'm saying?
Yeah, which is and that's too bad. And I think that's.
Let me just finish it though.
Yeah.
Just tell you what came of it. This guy didn't know me. Well, he went up some paperwork. Well, he shouldn't be in this position. He shouldn't have access to these rooms. So they took my key to the office away where the money was. So they took that away. I'm like, all right, no big deal. I was gonna go to another job anyway, because you can switch grades and stuff like that, go to different jobs. They hire internally, stuff like that. So I'm there. I'm in the union, so whatever. He don't want me no more. He doesn't want me there. I had to speak with Richard Meyer. He's the HR specialist, and go through all the channels. I got to know everybody, So then I end up getting a better job just because of what happened there. That was kind of discrimination, big time. So lawyer, the union, they ain't got nothing to do. So they barking like crazy. I ended up getting like $3,000. Sat down with the director of the hospital. He met with the president, all this, So he knows me now. He got me a job. He like, I don't care where you get him at. You're gonna find him a job in this place. You get what I'm saying? Because I just shared with him, you know, it was just 100%. And they made mistakes. They feel like they shouldn't. I wasn't supposed to get hired. I'm not a vet, but applied for the job, got it, and everything went well. And yeah, and I met with Richard Myers, the HR specialist, and the director of the hospital. You know, sat in these offices. I ain't never been way up there. You know, and it was just a beautiful thing to go through that process like that and get turned over, like because of like, you know, like the what is the senator that said he doesn't know the ripple effect behind it. You know, just certain little small things that people are just pushing buttons and signing off on it. You know, oh, this is a mistake here. You know, and not really looking at it, the individual. You get what I'm saying? I was employee of the month at this hospital.
Right.
That's hard to do. There's so many people at this hospital. And, you know, just to, yeah. So certain little small things like that, the turnover, I'm saying that saying that you're not, the documentation could say this, but it can be changed. There's always ways. There's always somebody that can say, like, just let that one go by right there. And that's exactly what happened in a federal job, in a federal, yeah. And then that's why I know things are possible. And I, you know, got a better grade, got paid $4 more, less work.
Perfect. Well, and if you were able to advocate and you had the union to advocate for you, and you know, that sounds like that went how it should have gone for sure. So, but yeah, so I do think, you know, part of our job though will be to tackle this specific list of disqualifying crimes, and to specifically tackle what really should be on it. You know, is it more broad than the federal? And are we pulling in more than really what the federal does? So that's that is part of our job, and that is the plan for today's meeting and the next 2 meetings. And of course, if we finish early, then we can always move on to the next one, which is going to be, I believe it's the preponderance of the evidence, which I think some of what we tackle here may translate pretty quickly into that too. So Mr. Okay, as you put your hand down, I wasn't sure if you had another question. No, that's totally fine. So I know I kind of jumped in there. Why don't we, Mr. Vogel, if you don't mind, we can turn to you.
Certainly, Madam Chair, and thank you. So I actually prepared a lot of this for the issue of permanent bars rather than permanent disqualifications. So I apologize for that, but I am prepared to talk about the thumbnail legislative history of both of them. So permanent disqualifications are, as you know, in 245C 15. And 245C itself dates from 2003, where it's essentially a recodification of 245A.04, as I recall, which had been built up over the 90s with, you know, essentially the structure that turned into 245C. The look back periods, you know, the 15, 10, 7-year, and the permanent look back period for disqualifications were enshrined in 245A in 1997. And that was essentially it was presented by DHS testifiers at the time as a department bill. It was essentially the department had been empowered earlier in the 90s to make rules regarding crimes or conduct that they found that would pose an unacceptable risk of harm. And essentially, they were trying to have codified in statute a unified scheme with a unified with a list of crimes, with a unified structure of look back periods. Excuse me. In the interest of administrative streamlining and fairness, they made the point in their testimony, for example, that often in their rules that they promulgated, it was effectively a permanent look back period for the entire list of crimes. So they got the look back period structure that effectively we have today out of a task force that was set up in 1996, which its task force is all the way down. Unfortunately, I've not been able to find information regarding the task force and its specific reasoning. I'm still working on that with the library, but apparently that task force recommended this structure, which then got enshrined in 245A in 1997, and then that got transferred into 245C in 2003. And that's sort of where I stopped that line of investigation with 245C15. But in the case of 245C 2.24, which is the permanent bars, we see permanent bars come up in 245A beginning in 1993. And it's effectively the same structure as when 245C is created in 2003. It's permanent bars for a particular list of crimes. I haven't had the time to compare them directly to the list of crimes in elsewhere in 245A, but permanent bar for a particular list of crimes, specifically for child-related activities, childcare, adoption, that sort of thing. It's in 2005 that we see 245C24 amended so that now it's a permanent. So now everything in 240, everything that's a permanent DQ under 245C15 is a permanent bar, and it's amended so that it's a permanent bar for all DHS licensed human services work. So I'm still delving into the committee hearings and the like from that year. Mr. Esme.
Yeah, can I just parrot that back to you to make sure I'm understanding? So the 05 revision did two things. The first is that it created the bar to a set aside for anything that was on the permanent disqualification list, right?
Yes.
And then the second thing it did is prior to 2005, that permanent disqualification list only applied to childcare background checks, and so it extended it to everything under the umbrella of 245C.
Effectively, yes. Childcare and the like. I don't have the statute up in front of me right now. If you'd like, I could pull up the 03 version. But it's
that's
activities.
That's great. I wasn't aware of
And so
that
before
part.
it was just the Adam Walsh stuff and the federal stuff, and then it was everything. Well, that's
Effectively,
what we think, right?
It looks like that to me, yes. And I should note, I've not delved into the hearings from that year, but this is in the aftermath of the murder of Drew Shadeen, and as I'm sure some of you are aware, that had a lot of impact here in Minnesota.
It would be good to know that for sure.
Yeah, and I'm working on that right now, Ms. Evans.
Yep.
Yeah.
We don't want to say that and have it not be true. You know what I mean?
Absolutely, yeah. So that's sort of a thumbnail sketch that I've got right now, which, as you can see, is definitely a structure for work in progress like that.
Yeah.
But that's sort of what I've got from there. And just as an extremely brief thumbnail of 245C.24 after 2005, the general trend line appears to be creating carve-outs. The next year, for example, we have added the I'm trying to remember now if it's a set-aside or variance capability, but the ability to get around that for the chemical dependency field, for example. So it's sort of, without trying to read too much into the legislature's of intent into the legislature's actions, it seems like 2005 is something that they've been, in a way, chipping away at in 245C.24 since then.
Yeah.
So,
yep, and that was the intent of the 2008 group, was to the collateral concept was to make some kind of dent in what the 2005 stuff did. Like they talk about it at the beginning of this. So that makes sense.
Well, can I ask a question?
Yep, Mr. Esme.
You mentioned the revision for alcohol and chemical dependency.
mhm.
Am I right that was limited though to grandfathering in people who had already been given a set aside before the permanent bar happened? Or does it allow for a set aside for otherwise permanent disqualifications on alcohol chemical dependency?
Mr. Esme, if you don't mind, I'm going to punt on that for a minute or two.
Okay.
Look at my notes and text the statute and get back to you.
Okay.
Mr. Esme, yes, you're correct. It was a grandfathering in 2006, essentially.
Okay, so then just so we're all on the same page, kind of the implication of that is right now there is no existing carve out or safety valve mechanism. If you're disqualified permanently for any job within DHS, unless you had gotten grandfathered in the 90s, you're disqualified. And so if we wanted there to be exceptions for alcohol chemical dependency stuff going forward, that would be something we would want to put in.
And thank you for clarifying that, Mr. Esme. That's something I should have caught.
And just to kind of track on that, that's one piece that I think is perhaps interesting and something if we do want to consider that more, because the Adam Walsh, I mean, literally the title is foster care. I mean, that's really what we're looking at and why it's there versus the chemical dependency field. And it just, there's different functions. And so there seems, and I don't know how this group kind of feels, but start maybe, which could get complicated, but sort of actually separating them out, which is what the federal code seems to do.
I mean, I think it makes sense to recognize that not all of the jobs that fall under the umbrella of the DHS background study need to be treated the same.
Well, and I think also even, this was a few meetings back, Mr. Hansen had been here. Hi.
There we go. Thank you very much. That worked.
All right. Well, enjoy your day.
Thank you. I appreciate it.
Was that also a carve out or a exception or something where people don't actually have direct client impact or contact, I mean, where right now everybody has to go through the same background study, even if there's no contact. So I know that was something that was very important. At least I gathered kind of from the employer perspective.
Mm-hmm. Yep. And I think too, would like to figure out how to like present that to the larger group, that there should be some kind of differentiation between what requires the federal mandates because there are children involved, and like how do we present that with this information to the larger group? Because I feel like that that's a super important piece of information for them to understand, that there's like that mandate and then there's everything else. And so
yeah, I mean, would you, I guess, and maybe this is a good way to, maybe if we start just sort of looking at that, and I know the permanent, we'll get to the permanent list here soon, but to me, at least I kind of see it as maybe three, we keep calling them buckets, but that terminology has worked well for us, of the three buckets. So any child related, childcare, foster care, adoption, kind of any of those lines, the chemical dependency. And then I guess I also throw out the vulnerable adult, the nursing home, the long-term care facilities, things like that. I guess in my mind, they're different, and we might have different considerations for them versus the chemical dependency. I don't know. What do people think about that? Just as, again, as we're starting to talk about these actual permanent disqualification lists, if we want to look at them separately to sort of figure out how we want to look at who it applies to.
So people in substance use disorder are considered vulnerable adults, though.
That is true. And that's probably too broad of a term. So I guess to me, I think nursing home different than chemical dependency. So I don't, whatever ideas people have. Mr. Tatum.
Yeah, I was thinking like, I know I don't do this one, but I know what is it, the PCA workers? I know a lot of them has been affected. I don't even know about this. Before I even knew about this DHS problem, I already knew this existed. Like far as with people with the because there was one guy that was in there earlier, and when we first started, they were saying that he couldn't be his mother's PCA worker. And I know other people that's happened to before as well. That's just like a lot of that's been happening, and I know that's happened in the Black community for me that I know that I'm connected with. So I know that's
a really good one to point out.
Yeah, like just
sort of like alcohol and chemical dependency. I feel like that is one that there should be more permissive
Mhm.
guidelines.
Yeah.
I wonder if just as a basic framework, we maybe say Adam Walsh Act compliance is bucket one.
Okay.
Which is probably going to be the most strict.
Yeah.
Bucket two is alcohol and chemical dependency related. And that's probably going to be less strict. Bucket three is maybe the bucket Dewan actually just pointed out, right? Which is like family caretaker roles. Family care. How about family caretaker compensation? Because what's really happening in those situations is like a child is getting paid by DHS to provide, life, like end of life care or like, in-home care for somebody that they're otherwise going to be living with anyway.
Who
Or a
would
child.
provide both?
What's that?
No, I
Sorry.
would say who would provide better care for this person than somebody automatic empathy,
Right. Well, and I think that's true, but I think from the most important part from at least I think our like how are we protecting people point of view is that these people are going to be in constant contact anyway. We're not giving the person who is subject to the background check extra access to the vulnerable person because they're already family, right? So it's like, what are we even? What is even the point of this background check? And then so those are sort of three separate buckets, and then maybe for now we just leave everything else as like general vulnerable, vulnerable people statutes, which will apply to basically everything else, and maybe we identify other carve outs going forward, but.
Well, and I think so that would technically be 4 buckets if I'm sort of, okay, I just wanted to make sure I was understanding. So we're really talking 4 buckets. Okay. And I think that because the family caretaker one, I can see why that to me is sort of the least restricted, almost like if we're going to tier it is the right word, but sort of prioritize.
And they're already doing some work around that family caretaker stuff, but not with vulnerable adults, with children and families, like kinship care. So I wonder, aside from the Adam Walsh stuff, which is way less restrictive than what we do, if those kinship caretakers would fall into that same bucket with foster care and I don't know about adoption, but.
Who's doing that work?
Oh, they did it with the Family Preservation Act. They started on it. And I know it's important for Ramsey County talked about it, but I know it's important to Miss Sherlock and others that we keep remembering those folks as well. Because like Ramsey County is just choosing not to get paid with Title IV money to keep kids with family members because of the laws.
And I wanted to ask about that. That's really what we're talking about with the Adam Walsh Act, right? Is that it is if you're getting federal money that is disseminated through the state, then you have to comply with that permanent disqualification list.
Mm-hmm. Yep, it's funding.
So maybe we will even like want to limit our Adam Walsh Act bucket to just foster placements that are funded through federal programs. Like, do we really maybe we want to be more like Ramsey County decided they want to be more permissive if they're going to let grandma, adopt grandkids, right?
Yeah.
I see it. Welcome, Max.
Hey, everyone.
Hey.
Hey, Max.
So, Max, just kind of a brief rundown so you at least know kind of where we're at. Our last meeting, we really just ended up outlining a schedule. So today is our first day of really talking about the permanency. And really, because this question came up before you joined, when we're saying permanency, at least for our meeting today, and if you join either of our next few, we're at the moment only talking about the permanent disqualifications under 245C.15. We're not talking about the bars to the set aside at the moment. We've kind of pushed those to a different agenda later in our process. So we're not ignoring them, but that's just not what we're doing for these next kind of few days. And so where we had just moved to then was just as our subcommittee has been doing research and really looking at the Adam Walsh Act, which you are probably most familiar with, any of us. We're all attempting to make ourselves familiar. Is really what we were just talking about actually was for the disqualifications, actually looking at the populations that are served differently, because right now the statute looks at all populations the same. And so the terminology that our subcommittee has often used is buckets. And so the kind of 4 buckets that we just started formulating, just so you know, these are very literally within the last 5 minutes formulated. So number 1 would be Adam Walsh Act compliance. So we're looking at those foster care, child care programs. So anybody that's going to be looking for that Title IV funding, 4E funding. The next bucket is alcohol and chemical dependency related population. The third bucket is what we're calling the family caretaker compensation. So we're really looking at those family members that not outside the foster care, but where you've got sort of that end of life and you've got a family member involved with the caretaker, like the PCA, where so often we have family members that get PCA hours to actually care for their actual family members. And then the fourth bucket is sort of just more general. We're, at least at the moment, we've labeled it other vulnerable adults. So that's your nursing home, long-term care, PCAs with your non-relatives, kind of things like that. Just because as we're looking through a lot of this, I think sort of looking at who really needs to be protected. And so do they all need to be classified the same? So that literally is when you jumped in. I now have you up to speed. Ms. Evans.
Yep. So just to be clear, though, we're not just talking about vulnerable adults when we're looking at this, because it's retail, it's commercial, it's like, it isn't just licensing boards, and it isn't just like this is, it affects more people. Like, I want to just remind everybody how broad this really is. It's cosmetologists, it's barbers, it's real estate agents. Like it's not just vulnerable adults. I just want to remind everybody, like, this impacts.
The nexus, though, right, is like, and maybe my understanding of it is wrong, but it is DHS licensed facilities, and which, tend to be things that work with vulnerable people, and then overlapping, but sometimes separate from that, people who are going to have access in their job to vulnerable people, so they might not be the caretaker. So some, like they might be the janitor, they might be food service, like they might be some of those other ancillary like services, but they are doing work in a situation that gives them access to vulnerable people, right?
Yep.
Yeah. Okay. Yeah. And so far, bucket 4 is just like everything else that's currently in the statute that we're not addressing in the other 3 buckets.
Chair Dawson, I do have to leave for just a moment. I joined slightly prematurely. I will be back shortly.
That's fine. Sounds good. And then I know while he's going to come back, I also am just making a note that we're talking about direct contact versus, I don't know if it's just easy to say no contact. I know that was very important for, all I remember is his last name was Hansen. I don't even remember who he was associated with or anything like that, but.
The Ben?
Yes. Yeah.
I think, I'm sorry.
Yeah, nope, it is really important. And I know, I can't remember who it was that I talked to that isn't part of this. It was when I was rallying troops to be on this board. Somebody has a carve out for laundry, food service, and housekeeping. one of the professional associations has a carve out. So.
It'd be interesting to figure out which one.
Yeah, because
um,
I think maybe what we're dealing with here is just ambiguity around when DHS decides to do background studies. And if I remember right from one of the employers, it actually sounded like it might even be more ambiguity on the perspective of the employer, where they may be actually sort of sending more things to DHS than need to be. And then DHS might just do the background study, whatever, if the employer asks them to. But like in my mind, no contact should have no background study at all. It shouldn't be a question of whether there's a permanent disqualification. And then maybe the more complicated question is, your housekeeping at a group home, right? Where they're going to be going in rooms where vulnerable people are unsupervised, but not providing care. Like that seems to be like the more tricky thing to me. But like the accountant who, isn't doing anything with vulnerable people, just happens to work for the organization. Like to me, I feel like maybe we should look at that, but in a different perspective of like trying to figure out how we can empower DHS to just say, no, we don't need to do a background study on this.
Ms. Williamson?
Thank you, Chair, and hello, members of this subcommittee. I just, so far what I've been hearing sounds great. I just wonder if I'm so leery as far as interpretations, right? So I wonder if there's a way for us to get a better understanding of how access is defined as far as those requirements, because where we're thinking someone that's working in the kitchen should not be considered someone that has access, but that very well may be why that requirement is there, because they're defining it as just being in space, being within so many feet of, said person. So getting that definition, I think, would be very helpful.
No, I think that that's a good point. And I think that definitely kind of even goes to what Mr. Esmed just said about housekeeping of you're going into the room, the person may be there. So technically you have contact, but you're not taking care of the person. Mr. Esme?
Lucas, can we get sorry, Josh.
I got it right here.
Okay.
It's 245C02, subdivision 2, says access to persons served by a program means physical access to persons receiving services, access to the person's personal property, or access to the person's personal, financial, or health information without continuous direct supervision as defined by subdivision 8. And continuous direct supervision means an individual is within sight or hearing of the program supervising individual to the extent that the program supervising individual is capable at all times of intervening to protect the health and safety of the person served by the program.
So basically, if they have access to either that person, their personal space, or their finances, that's considered full access. Which
to me is those other parts are probably there because the way the statute is right now, I mean, the misdemeanor thefts and those other pieces that I wonder I think the disqualification subcommittee is looking more at those more misdemeanor and specific crimes, but I wonder if some of that, if there are alterations to the actual crimes, those wouldn't be necessary anymore. So no, I think that's helpful. And to me, then it's the laundry, food service, like you just said, the accountant, those are different. The housekeeping, I don't
think they are different. I mean, I think all of those meet the definition of access.
No, I would agree. They meet the definition of access, how it's defined now.
Yeah. Okay.
Yeah. Yeah, it's hard though, because you look at, that's the thing about it, like there's no differentiation based on the crime committed to the risk of harm, right? So if somebody's, and I always use the drug possession, right? If somebody's crime is a drug possession, like what does that have to do with if they're in personal space with somebody? Like nothing, right? The risk of harm based on their crime. Like if the thing that person did was theft, maybe you don't want them with someone's personal property. Or if the thing that they did was like, got into an argument with their girlfriend or like whatever, like that's a different thing. And so like, I don't feel like the way that it's like you treat everybody the same, right? Everybody in the bucket. There's no differentiation between the crime committed and the actual risk of harm in the end. And so like, how do we do that in a way that doesn't create more of a backup? Because that's the other thing. Like we can do all this stuff, but if at the end of the day, it just creates more of a less of a unified structure of look back periods for DHS, it's just going to make it harder and take more time. And so whatever we do, it's going to have to be uniform. Max has his hand up.
I think it was still up the whole time.
Okay, got it.
I don't think he ever got it down.
So that's the other thing I just want us to really be cognizant of, is that whatever we're going to do, they're going to be bright, easy lines for DHS. Because if we just create more systems for them, it's just going to take longer for stuff, and that doesn't help. So
Chair, if I may, I know data, our next full meeting, we're planning to categorize the information that we have thus far, the data. And I know as a start, I'm looking to present to the subcommittee with categories where we're looking at like categories of crimes against people, categories of crimes against property, categories of crimes of poverty, like being able to categorize them in that sense, is something I think is kind of like the start to how we would look to kind of aim these recommendations where, kind of to Vice Chair's point, there is somewhat of a formula of how these crimes are categorized. So then you can know how to apply whatever the disqualification steps are applicable to that particular category.
Yeah, I mean, and I get what you're saying, and I think, well, and I suppose, I mean, as far as the Adam Walsh compliance bucket, I think that one, I mean, honestly, at least what I'm seeing, at least what I've figured out so far, as I've gone through some of these rabbit holes, is they really are more person-related crimes. There are some drug-related offenses, which I haven't dug yet into that bullet point. But the actual, I guess, crimes of poverty, the theft, the welfare fraud, that's not mentioned in Adam Walsh. So to me, I think Minnesota brings in more of those poverty crimes more related to poverty than the
I don't
federal.
think those are in a permanent disqualification bucket though.
No. Well, there
I
are
mean, it almost looks to me like,
I don't know, identity theft, issuing dishonored checks.
oh really?
Oh, no, I'm sorry. That's the 15-year. You are right. Sorry. I had the wrong page in front of me. I had printed some of this. No, those are 15-year, which honestly, even under the 15-year, those wouldn't be covered under the Adam Walsh 5-year.
Right.
So even under the Adam Walsh 5-year, I think there's less of that, at least from what I can tell, there's less of that crime of poverty.
Is the Adam Walsh, I'm looking at 42 US Code 671,
Yep.
State Plan for Foster Care and Adoption Assistance.
Yep.
And there is a subdivision. I can't figure out how far it is down, but it basically says,
I think it's subdivision 20.
yeah, 20A2, 20A1.
Yep.
In any case involving a child on whose behalf such payments are to be so made, in which a record check reveals, and then here's where we get the basic list. So a felony conviction for child abuse or neglect, a felony conviction for spousal abuse, a felony conviction for a crime against children, including child pornography, or I assume this is a felony conviction for a crime involving violence, including rape, sexual assault, or homicide.
Well, a crime of violence is defined by federal code.
Okay. But not including other physical assault or battery. Oh, so maybe this actually isn't a felony conviction. So other crimes of violence, including rape, sexual assault, or homicide, but not non-felony assault and battery. So I think just a real simple comparison, I almost wonder if subdivision 1 of 245C15, our permanent disqualification list, was actually just an attempt to pick out every Minnesota statute that could fit that definition.
Well,
Rob,
so
will you send me that link you're looking at, please? Whatever you're looking at right now, will you send it to me?
and so that is what I was starting to work on, to actually go through that as to what exactly those were. And that's where it was starting to become a rabbit hole. That so far, what I can tell, I think, because our permanent list includes, but our permanent list includes manslaughter, domestic assault by strangulation, some of these others that I have not finished going through them and actually going through the federal code to figure out what all was there. In my notes, was working on it before our meeting, that I don't have that. So I am working on that to try to kind of bring to everybody as to what exactly those are, to see if they do actually line up. And I know Max is back. Max, do you happen to have, when you were doing the Family Preservation Act, I know you guys did a really deep dive into the Adam Walsh. Did you ever kind of delineate out, that's kind of what I was trying to work on, was when it says, for example, a felony conviction for child abuse or neglect, did you kind of figure out exactly what those were specifically? Because some of these seem to be broader terms that then you have to dig into the federal code to see exactly what it is they're defining.
We choosing the crimes and their disqualifying period, I will say, was more of art or arbitrary than science, or based on any necessarily any legal analysis. We started off with the bare minimum of things that we thought needed to be included, and those you will see are in our permanent disqualification list in the new foster care licensing statute. There were a few others that were added just for, I think, what you would consider political purposes or in order to get the bill to pass. But we didn't. Joanna Woolman may have gone closer and said this one fits within Adam Walsh, this one does not. But to my knowledge, I never saw any graph or table that said here's what someone would say legally falls within that definition, and these do not, especially on some of the closer calls.
Okay. No, and that's helpful. And because I was trying to see, of course, if somebody else had already done the work specifically, and at least the federal is, for example, just even by way of example, the Adam Walsh uses the word rape. That's not actually listed within the specific crimes. There's sexual assault. And so, for example, that was then bringing me to the only place I could find rape was under the uniform criminal something, which is essentially forcible penetration, which is our first degree CSC. So but it's not a tracking specifically. So that I've spent a few hours on it and I will definitely put in some more time. And I would like for us to all be able to look at it so that we actually know what we're talking about. It's not like I can go in and click and it's right there. Sorry, I don't know who had their hands first, Ms. Evans or Mr. Esme. I apologize.
Go ahead, Josh. Unless you're going off on something completely different.
No, this is direct related. Just to the to elaborate just a little bit on why I am guessing that our current subdivision 1 was somebody's attempt to just write a list of Minnesota crimes that are Adam Walsh compliant. A couple of the quirks about that subdivision 1 list that I've always wondered about are there's a handful of disqualifying crimes that are limited to only felony offenses. So a felony offense under 609(3)(7)(7), malicious punishment of a child. So and similarly, like the felony assaults, and then some other types of crimes that are on here that it doesn't matter whether it's a felony conviction for them or not. And even one non-felony like level crime altogether, which is 5th degree criminal sexual conduct, still makes it on there. And if you look back at that definition in the Adam Walsh Act itself, you get this sort of same kind of interesting, like some felony convictions for child abuse or neglect, but then any other crime of violence except for basically non-felony assaults. It seems like that list lines up with the quirky parts of our subdivision 1 regarding which things have to be a felony conviction to be permanent.
Well, and I will tell you though, I interpreted the Adam Walsh to only apply to felonies because felony is used in the beginning and then at the end. So I
don't think that's right though.
Actually apply to all felonies.
Or
to only felonies. And then the 5 year.
I think we should figure that out because it's that there's that list before the clause with the or.
Mm-hmm.
So it seems like felony convictions for child abuse, neglect, spousal abuse, and crimes against children. And then there's an or that now drops the felony part and says for crimes of violence, and then has another list that excludes other physical assault or battery.
Well, and I guess I read it as or for a crime of violence, including rape, sexual assault, or homicide, but not including physical assault or battery, if a state finds that a court of competent jurisdiction has determined that the felony was committed at any time.
Oh, okay.
So that's where I got that it applies all to felonies. And I don't know, Max, I know you weren't originally coming in to give any guidance on that. So I don't know if you.
Hold on, before we turn it over to Max, just one more time in defense of my reading of it. Again, I wonder if that if a state finds that a court of competent jurisdiction has determined that the felony was committed, I wonder if that was read at least when 240 our list was made here as being only applying to the physical assault or battery. Like that would be the language that says it has to be a felony 1st or 2nd degree assault. Basically, it has to be a felony assault to be a permanent disqualification. But that doesn't apply to other crimes of violence other than assault, right? Which is why we get, all of these other things that are permanent disqualifications no matter what. But
Mr. Esme?
Yeah.
Madam Chair, I think I should point out the next section of.
That's what I was going to say.
Yeah, that statute includes felony conviction for physical assault and battery as a 5-year.
So I think that's why it separates out, but not including physical assault or battery, because those are covered by subdivision 2.
Mm-hmm.
So then those don't even need to be in our statute for it to be Adam Walsh compliant.
Well, they do as far as a 5-year.
Right, but they're impermanent right now.
Yeah, exactly.
Okay.
Yeah, so if physical assault and battery felony is only a 5-year, then misdemeanors for sure wouldn't be permanent. Right. I mean, that doesn't even make sense. So, I have to go. I have a meeting with my boss at noon that I can't be late for. And so thank you all for your work and, yep, appreciate you.
Thanks, Gina.
Yep.
Thanks,
Did
Gina.
I just cut off Max? I think I just cut off.
I got a training session. These people are showing up here. So I gotta.
Oh, no. All right, you got to go too.
At
All right.
noon, yes.
Max, while you're here, if you wouldn't mind, if you want to weigh in, well, and Dawn, thanks for, we'll see you next time.
But I just want to say I was really interested in what you were saying about like the manslaughter thing. I kind of took my attention. I had some other stuff I wanted to elaborate. But
I was starting to look into the manslaughter one, and I would tell you, I know you have to go, but my thought is I will try to have all of this done and organized, and maybe at the next meeting I can sort of give some more feedback on that, because the manslaughter is one I was actually just getting to, and then the meeting happened. So
they said, well, I was going to go with the mental aspect of it. You're just
perfect.
thank you guys. I'll see you guys in this one.
So I guess if I'm sorry I had to pop out for a minute. We're still talking about 245C.15, the permanent disqualifications.
So yeah, we were talking about where we had jumped to then was the Adam Walsh interpreting that if it kind of that whole paragraph about the permanent disqualifiers under Adam Walsh, just Adam Walsh. We're only looking at Adam Walsh at the moment, not the Minnesota statute. I think Mr. Esme and I were kind of going back and forth about if it only applies to felonies, or if, for example, the Adam Walsh would cover, I don't even know if I'm not even licensed. I don't do federal, that's other attorneys in the office here, but if that would cover, let's say, gross misdemeanors or something like that under Minnesota law.
And I think to answer the question then, and it is my recollection from a year ago now that we interpreted it to only mean felonies, but I would have to check with Joanna to make certain of that, because there are, of course, gross misdemeanor level child abuse and malicious punishment type cases, misdemeanor level assaults, and criminal sexual conduct. I guess, our current statute, I think it's worth pointing out, and maybe all have already covered this, but it talks about the commission of an act rather than a conviction. And that's a pretty big distinction. And then I know subdivision 1E talks about the sentencing, if it's sentenced at a lower level, because that's also something I think our group should really take into consideration, is whether you are charged with something is a completely different question about whether you plead to a lower count, or whether there's a preponderance of the evidence for an administrative finding. Those are all, when we wrote our statute, we used a conviction date for, some of those serious ones. So, yeah. I guess leave it at that. I don't want to take it too far, of course.
No, and I think that that's helpful, and that is definitely something one of the tasks that our group will be looking at is for sure that preponderance of the evidence. And I think it's for sure helpful to bring us back to remembering that the statute also does talk about if somebody is sentenced at a lower level. I think that would actually fit in probably well with the preponderance of the evidence portion, but that is something we will be talking about. We have these next two and then the one after that. So that is a topic we'll for sure be looking at.
And Chair, if I may, to Attorney Page's point, somewhere where we are highlighting that verbiage of commission versus conviction, because as we learned at our last task force meeting, even just the admittance, especially with juveniles, which is what I work with every day, how they're thinking they're getting these stay of adjudications, and that's not they're, yes, it's being dismissed in a sense, but it's still following them. So
right. And I do think that is for sure is something our group I will be looking at, because I think that falls in line. And I keep just saying the POE standard, but really I think the plan is to look at all of those. I think right now it's just literally that permanent list that we were kind of tasked with, and then those will be some later meetings as well. Mr. Esme?
Not to try to get us off topic here, but something that Ms. Williamson just said triggered a thought in my mind, which is, we think the Adam Walsh Act compliance, it specifically uses the term conviction, right? Like, could we cut all juvenile delinquency related disqualifications out of that bucket altogether if we wanted to?
And I thought at one point I saw that the Adam Walsh could cover some juvenile records. I haven't found that yet, but I thought at one point it did, some, but not all. And I feel like I've gone back and looked at it several times that now I don't remember. And Max, I don't know if you, I know you, this was like a year ago for you. I don't know if you remember.
I don't recall specifically.
Okay, I will make a note.
Yeah, that would be important for us to clarify that, because the juveniles cannot be convicted. So therefore, why are they falling under this umbrella?
Right. And I do know, I don't, how much, depending on how much we really want to go into that, because I know the disqualification subcommittee has also been looking at that one. And maybe that's a good question for me to raise with Chair Geffen, because he's the chair of that subcommittee. Just because I think our group has a lot to tackle, that I don't want to get, if he really wants to make sure that the disqualification subcommittee is tackling all juveniles, whether, you know, admission, no admission, or, well, I guess some of that, but I know some of that relates to us too. So why don't I, as far as the group, I will connect with Chair Geffen and report back.
And Madam Chair, if you could please just repeat what are the categories that have been brought up in this meeting today?
Yep, just one, hold on a second here, sorry. I just wanted to write a note for myself to circle back with Chair Geffen. So if I don't make a note, it doesn't happen. And I'm happy to do that.
Before you do that, can I just jump in real quick? I think that's great that the disqualifications committee is looking at that. Since we are tasked with permanent disqualifications, though, it might be a pretty easy lift for this group, especially in light of the testimony that we had at the last full meeting regarding adolescent brain development, to just say that no permanent disqualification is appropriate for any juvenile.
Well, and I think that that's even consistent with, let's say, US Supreme Court in Minnesota. I think Minnesota is also kind of shifting with that, where, you know, juveniles can now not, I guess they can still theoretically, the life sentence where they need to get check-ins, and I forget exactly how, it's been a while since I've looked at that case law, but I think that makes sense. Yeah, and I will check in with Chair Geffen on that though too. So, okay, so back to you, Ms. Williamson. So kind of the main things that I think we really, are you looking for the 4 buckets that we outlined?
Yes, please.
Okay, so the 4 buckets that we had outlined as to whether we're going to look at them separately, the we're calling it the Adam Walsh Act compliance bucket, the alcohol chemical dependency related bucket, the family caretaker compensation bucket, and then just a very broad other vulnerable adult bucket, which nursing home, long-term care, PCAs. I know Gina brought up just anyone who has contact with those individuals. So those are the 4 buckets. And then of course we still have, I think at this point, from what I gather from our conversation, we're still really just looking at the Adam Walsh and trying to figure out exactly what that says and exactly what that disqualifies, as well as separating out, I I think even with that, and it's sort of a separate bucket, but those with direct contact versus no contact. Does that sound right?
Thank you.
So
Okay. Thank you,
with-
Chair.
yeah, so without Ms. Evans and without Mr. Tatum, and it is 12:09, I'm wondering if it makes sense, if we want to adjourn. I will, in the meantime, connect with Chair Geffen and continue some of the work I was doing with the permanent bars. And I apologize, I was looking down, so I don't know who raised their hand.
Max beat me
All right.
by
Thank
like
you.
half a second, but he did beat me.
It was a hair, Madam Chair.
Hey, go ahead, Max.
Just because I have a conflicting meeting with when this group regularly meets, and I've been invited, but just haven't been able to make them. I just wanted to let folks in this committee know that I think I was invited to this group to present or the opinion or the stance or a contrary stance relating to public safety when it comes to permanent disqualifications. And I guess I just would make a quick statement that, the County Attorneys Association, including my office in Hennepin County, cares mostly that people serve their time and pay their debt to society and don't want barriers to exist after that has been done. And so to the extent that this group is considering, processes to allow people access to jobs after, conviction, after they've served their prison or probationary sentence. I don't know that there is necessarily a strong objection to including more crimes on the permanent disqualification list than would be legally required federally, say by the Adam Walsh Act. I think to the extent that the County Attorneys Association particularly cared about the statute, it applies to the foster care licensing statute, which of course was modified last year and is not under the purview of necessarily of this background study task force. So I would say our interest may not be as high as it would have been had that been included. I will say, public safety applies to, or public safety principles applies to protecting vulnerable adults, of course, and we would really want them to be protected. So to the extent that a crime is removed from the permanent disqualification list or and into a lower tier, we would want proof of some sort of demonstration, maybe that the individual has been rehabilitated, has worked towards changing their situation. And so maybe that's something to consider for the group too, is rather than permanently disqualifying someone for a crime that's not legally required under federal law, that the burden of proof changes to them and that they be able to demonstrate that they are able to do the work, particularly with the vulnerable populations, and have that be the determination. So I will leave it at that. I'm happy to attend in the future. Excuse me. When I'm able. What's up?
So I feel like you've sat in on just what you're saying. I feel like you're echoing a lot of the things some of us have said before.
Well, I appreciate that. I have been asked by Ms. Evans and others to say, aren't the County Attorneys Association and law enforcement, aren't they these people who don't want people to ever have the state get off of their back? And we certainly don't want convictions to necessarily haunt people for the rest of their lives. We want them to be able to participate in society, including with employment license by DHS if it's safe and appropriate. So, as with all of these things, the devil's in the details on how something would work. But on behalf of those interest groups, I'm happy to discuss those further.
Thank you.
Appreciate that.
That was really helpful. Thank you. And I was trying to furiously take notes while you were saying some of that too. Mr. Esme, did you?
Yeah,
still-
I just wanted to ask if there's anything I can help you with in prepping for the next meeting.
That actually, I would love some help on some of this. Why don't I was trying to have more done, and then I had a client step in right before this meeting. So I don't even know where I left off with what I was working on the Adam Walsh. I have to probably eat some lunch so that I don't have hunger getting in the way too. So why don't
When
I,
we circle back.
yeah, why don't we do that? Let's you and I maybe connect even sometime either today or tomorrow, just to maybe you and I just even have I can kind of fill you in where I'm at and figure out what makes sense.
Okay. Tomorrow might be a little bit easier for me if that's okay with you.
Oh yeah, that's totally fine. I was supposed to be in trial this week and it got moved, so I have no court. Knock on wood.
Wow.
I just jinxed myself.
Yeah, you did. You're gonna get the
Really?
2 a.m. You're gonna get the 2 a.m. call tonight now.
I jinxed myself really bad. So yeah, why don't, if we want to connect tomorrow, I have your email. I'll shoot you an email and we can connect.
Sounds good.
All right. Well, if there's nothing else, Max, thank you for coming today. Thank you for giving what you said. I definitely appreciate it. And it was very reassuring to hear. Not that I thought the county attorney's office was really wanting to take a hard stance, but it was actually, I think, encouraging to hear what you said, because I think some of what you said echoes conversations that we've had about really wanting to help people move forward while still keeping in mind kind of that protection and safety, and how can we make that happen? So thank you. All right. If there anything else before I adjourn? All right. Well, thank you, everybody. And we'll see you in 2 weeks.
Take care, everyone.
Awesome.